Hello, I'm Mark McSweeney, Executive Director of the Association Societies Alliance. Collectively, through our Society of Association Executive members, we represent over 4,000 trade, professional, and individual membership associations in 40 states, as well as New Zealand and Australia. We are proud to partner with our member SAEs and, of course, Jeff Tenenbaum and Nisha Thakker to provide this newest entry into our series of timely COVID-related topics. Meeting contract considerations during and beyond COVID-19, ask the association attorneys. Today's webinar is being recorded, and a link to the recording will be made available after the program concludes. All attendees of the live webinar are also eligible to receive 1 hour of CAE credit. Please note that there is no slide deck for today's program. During the program, we will have an opportunity for Q&A. To ask a question, please enter that into the question box on your screen, and we will be sure to ask the panelists to address those on your behalf. Now, before we get started, I did want to take just a minute to announce that the Association Societies Alliance is partnering with Wharton Marketing and Research to launch a new economic impact study, measuring the economic impact of associations in individual states across the country. Please check with your local Society of Association executives to find out if your state will be participating, and watch for those announcements soon. And with that, I am pleased to introduce our facilitator for today's webinar, Jeff Tenenbaum. Jeff is one of the nation's leading nonprofit attorneys and also an accomplished author, lecturer, and commentator on nonprofit legal matters. As managing partner of the nationally recognized Washington, D.C.-based Tenenbaum Law Group, Jeff counsels his clients on the broad array of legal issues affecting trade and professional associations, charities, and other nonprofits. For 19 years, Jeff practiced law at the Venable Law Firm and chaired its nonprofit practice for most of that time. Among numerous other honors and awards, Jeff was the 2006 recipient of the American Bar Association's Outstanding Nonprofit Lawyer of the Year Award, and is one of the only 5 lawyers in the prestigious U.S. Legal 500's Not-for-Profit Hall of Fame. Jeff is the author of the ASAE published book, Association Tax Compliance Guide, and currently serves as chair of the American Bar Association's Trade and Professional Associations Subcommittee and on the ASAE Legal Advisory Council and Public Policy Committee. Jeff, please turn it over to you.
Thank you, Mark, and good afternoon, everyone, or good morning to those of you on the West Coast. It's great to partner again with Mark and the Association Societies Alliance for another webinar. We've done quite a few of these now since the pandemic has been upon us from March, in March of last year. And every time that we do one of these, every time that we think we're going to be turning the corner on the pandemic, unfortunately, things seem to go in a different direction, and that very much has an impact on the issues that we're going to be talking to you about today, particularly regarding meeting contracts for your associations. Nisha and I and our colleague Julie, the three of us are the attorneys that make up Tenenbaum Law Group. We represent about 450 different associations and other nonprofit organizations, primarily as outside general counsel, dealing with a very broad array of legal issues facing associations like yours. For the last year and a half since the pandemic has been upon us, we spend a large part of our time every day working with associations in connection with their meetings and events, and now also counseling on a daily basis in connection with workplace reopenings, vaccination mandates, and related issues. Today, we're going to be focusing, again, as we have for several webinars that we've done for ASA, on meeting contract issues. For most of last year, we spent much of our time helping associations cancel or postpone their meetings and events due to COVID, and particularly due to the bans on large gatherings that were in place in many states and cities and counties across the country. And we had a really terrific track record last year, particularly of utilizing force majeure clauses, which we'll talk about today, to help our association clients get out of their meeting contract obligations with little or no cancellation penalties. As we turn the corner into 2021, and particularly when the 3 FDA authorized vaccines came online earlier this year, much of our focus changed from helping our clients get out of their meeting contracts to helping them figure out how to stage in-person meetings and conferences again in a way that mitigates liability risk to the association and protects the health and safety of attendees and staff. That was proceeding along, and we expected that to continue to proceed along well. Many of the meetings and events that were scheduled for last year were, for many associations, including yours, were able to be successfully rescheduled and rebooked for 2021 and later years. Now, unfortunately, with the Delta variant of COVID-19 very much still upon us and still wreaking havoc across the country, we are unfortunately now spending a good part of every day helping associations figure out how to either cancel or postpone their fall 2021 meetings. There's quite a few of them that were scheduled, and quite a few associations that now are concerned about holding in-person events. And while that is certainly the case for some associations, other associations are proceeding with in-person events. They certainly have occurred and continue to occur and are scheduled to continue to occur, but in almost every case with much lower attendance than was contracted for, creating a lot of issues and problems for associations, particularly when it comes to what's called attrition penalties. Those are the penalties that are built into most meeting and conference contracts, where you are obligated to meet certain guaranteed minimums for sleeping room revenue and food and beverage revenue. And if you fail to hit those marks by a certain percentage, then you can get hit with attrition penalties. So that's been another big challenge for associations going forward. And at the same time, amongst all of this, the regular contracting process for future year meetings has continued. And we've all certainly learned a lot from the last year and a half. And as a result, our strategies and how we advise our clients on their meeting contracts for 2022 and beyond has changed quite a bit. And there's a number of kind of particular tactics and strategies that we've been adopting and advising our clients on to help protect them in those contracts for future years. So the focus of today's program is going to be on meeting contracts specifically, both existing contracts for 2021 and beyond, new contracts that you are in the process of negotiating for your associations. But we are going to talk a bit about in-person meetings as well, particularly those that are scheduled for this year, to talk about some of the issues that I know you likely all have questions about. So we don't have any PowerPoint slides for today's program. We do have issues that we want to talk about, but we really want this to be driven by your questions. So please, I encourage you to ask as many questions as you want, and we will tackle as many as we can over the next 50 minutes. But to get us started, until we start seeing your questions coming in, Nisha and I do have a few kind of questions to pose to each other based on everything that we have seen and heard over the last year and a half, the challenges that our association clients are facing. And so with that, we're going to dive into that. So Nisha, let me ask you, in terms of meeting contracts, let's say your associations have a meeting scheduled for the fall or winter of this year. And let's say that you want to, your association is concerned about moving ahead with an in-person meeting and you want to consider trying to postpone it. We know that force majeure, that those are the provisions in these meeting contracts that say if an unforeseen event makes it illegal or impossible, or sometimes they're written to say commercially impracticable to hold the meeting, then the association can get out of that contract without penalty. Well, as COVID is no longer an unforeseen event, most force majeure clauses are really not of much help. Not always the case, but they're not really of much help in using that threat of a force majeure penalty-free termination as leverage to get out of your meeting contracts without penalties. So as a result, for those associations that are looking to postpone or get out of their 2021 meeting contracts, we have to look for other leverage, and it's not nearly as easy. The negotiations are much more difficult than they were last year. Yet at the same time, we have had a good amount of success in helping our clients mitigate their penalties in connection with their 2021 conferences and related contracts. So in light of that, what are some of the things that you've seen, that we've seen our association clients use as leverage to try to help them reschedule, rebook, get out of a 2021 meeting?
And that's really what we're dealing with primarily now. And that question of leverage is key in these discussions. Many of our association clients have long-standing pre-existing relationships with these venues. So they've been able to play on those relationships and utilize the history with the venue to potentially rebook their event to a future year or outright cancel with minimal penalties. The key, though, is to make sure you've gone into these conversations with the hotel with a plan. We've seen a little too often lately that either meeting planning companies or the association client directly is going to the hotel and using the word cancel, just saying without any sort of background or thought, saying we're canceling the event, what's next, rather than saying we want to engage in some discussions with you about our options. When you go into these conversations with hotels and venues about potentially having options to consider instead of landing on one particular outcome, we've seen the hotels and venues be far more amenable to discussion. So we want to talk to you about some options we have for our fall conference. We're noticing our registration numbers are significantly lower than what they are in the past. And we'd like to discuss potentially being able to reduce our room block, reduce our food and beverage minimums, and want to work with you on hosting a successful meeting. If that's not going to be possible, hosting a successful meeting, then the association needs to really think about what its end goal is going to be. Are you looking to cancel that event? Because if you are, you've got to dangle a carrot to this venue, right? To be able to say, we may need to cancel, but we're willing, again, to work with you on something that could be taking place in the future. We're happy to rebook with you in a subsequent year and host an additional event with you in order to reduce any of those cancellation penalties. But from what we've seen, Jeff, just to sort of go back, is the more open and early communication you can have with the hotels and the venues, or the more willing they are to work back with the association. But you've got to give them the time to come to some sort of an agreement. You can't let them know a week, 10 days prior to the event and expect to be out of that negotiation without any sort of penalty.
The message is the earlier you have those open communications with the hotel or the convention center representatives, the better. Your comment about going to a property and saying, we want to cancel, now what should we do next? It happened again today. We heard from another client, and in almost all of these cases, it's been the independent third-party meeting planners who many associations contract with for these services, who have gone ahead and just said to the hotel, we want to cancel the event, so what do we do next? And then what happens is we see the hotel come back, or the convention center, with a bill for significant cancellation penalties. And these cancellation penalties are designed to kind of make the venue whole for the profits they would have earned. And that means not only the food and beverage spend that the association would have incurred, but all of the room revenue that the association primarily is not incurring, but would have been the attendees who are paying for it. So all of a sudden, all of that comes back to the association in the form of really significant cancellation penalties. You absolutely want to make sure you do not do that. It's a strategy that just doesn't work. It backfires, and then we have to help the associations kind of dig their way out of it. If you, in some cases, these force majeure clauses can still be useful, and we draft termination letters, notices very regularly, even today, on behalf of our association clients, making the arguments it's not nearly as strong as last year when you had all these state and local mandates that banned large gatherings. Those don't exist anymore in most states. They do in Hawaii, but generally speaking, they don't exist in most states. And so you have to find other leverage. When you said, Nisha, you need to kind of dangle something in front of the hotel, you need to give them a reason to renegotiate. And generally, the best leverage is going to be a combination of our force majeure clause is relevant because it's dangerous for our attendees to attend. In some associations, a lot of the members are still subject to employer-imposed travel bans due to COVID. These are things that we utilize in the threat of a force majeure termination, but you're going to need something more than that. you have to, you want to have a proactive conversation with the hotel, and you generally want to do this by telephone or by video call, not in writing and not through attorneys. You should absolutely consult with your attorney to get advice and strategy and guidance on how to go about doing this, but you generally don't want the attorneys to have these discussions. Once it gets to attorney conversations, it generally is not, it doesn't end as well. The hotel is going to ask for significant cancellation penalties, and you need to give them a reason to not pursue that route. So for instance, some of the pieces of leverage that we've been utilizing, certainly the promise of a rebooked meeting, doing a meeting in the future where the hotel will have it'll be a much more successful meeting with hopefully a lot more attendees, a lot more profitable to the venue. That's the number one thing that you have in terms of leverage. But that alone in many cases is not enough. Sometimes it is. Every situation is different. The relationship you have with the hotel, is it a long-standing relationship? You have good personal relationships. All of that factors in. You know, how much of a great client is your association to that venue, but you're going to have to give generally something more. In some cases, some associations are still paying some cancellation penalties, but are able to negotiate a much smaller number. But one of the things that we've also used is saying, look, instead of cancellation penalties, let us give you a larger, or in some cases, a new, because it wasn't done in the past, advance deposit toward that future meeting. If you can give them cash now, which every venue needs and wants, that's an incentive. And so if you are just prepaying, for instance, food and beverage costs that you will be paying anyway in 2022 or whenever the meeting is rebooked, that's been a very successful tool that a lot of associations have utilized as another piece of leverage to try to incentivize the venue to agree to a rebook and not assess you any or at least significantly reduced cancellation penalties. So advanced deposits are certainly one thing that you absolutely should focus on. Sometimes you can offer up 2 meetings, you know, maybe rebook this one for next year and then offer another meeting, you know, 3 or 4 years down the road, whenever your next open year is. Maybe you offer up a smaller meeting, like a board meeting or something like that at some future date, but you're gonna have to give them some leverage. And in the end, you might have to pay some cancellation penalties as well. But these are the kind of things, and this is the sort of proactive discussion that you want to have with the hotels and the convention centers as early as possible. Nisha, in terms of, let's kind of pivot for a moment to meeting contracts. So say you're negotiating a new contract for a meeting for next year or the year after, or whenever it might be. What are some of the things that we've been kind of advising our association clients to do differently in their meeting contracts for future year meetings? A lot of the lessons kind of that we've learned through the pandemic.
Yep, so there's a couple buckets here I think we want to talk about. The first is sort of things to keep your eyes open for that are potentially dangerous pitfalls, and then a couple of provisions that we want to see included that you may not have considered in the past. So the first actually ties back, Jeff, to what you were just talking about, potentially offering an advance deposit on a rebooked event. So this is going to be a little different because with a rebooked event, you do have to offer the hotel some sort of incentive to allow you to rebook without that penalty. But when we're signing contracts for new events, we don't necessarily want to have to put in a huge deposit. And we are seeing a number of hotels and venues now requiring large advance deposits. So a huge amount due right at the time of contract signature, and then continued payments until you essentially get to 100% of the minimum spend well in advance of the date of the actual event. So when we're looking at these contracts, we are trying to get away from that for our clients, only because once the hotel has that money in their hands, it becomes increasingly difficult to get it back in the event of a cancellation. For example, over the past 18 months or so that we've had to cancel events for clients, those events that had deposits already on the books were harder to get a no liability termination through, meaning the hotel already had that money, so the group had to fight to get the money back. when the hotel didn't have any advance deposits, that termination tended to go a little smoother than what we had seen in the alternative. So we want to make sure now that we're really avoiding these huge deposit sums going to the hotels right out the gate. And also related to that are the cancellation penalties. You all, I'm sure, are familiar with the hotel chart that lists when your cancellation penalties are going to be due and at those intervals when the penalties start to increase. In these new contracts, just from the past, I would even say 6 to 8 weeks, the cancellation penalty chart has changed dramatically in that penalties are due much sooner than they were in the past. From contract signing to well over a year and a half in advance of the event, you're still looking at 50 to 60% of your total spend due in cancellation penalties if the group were to cancel the event. So financially speaking, we really do want to make sure we're looking at these contracts to say, what's the hotel doing or the venue doing to try to collect money well in advance of the event if something were to happen and the event couldn't go forward. So for our clients' perspective, we want to make sure they're holding their money longer than what the hotel wants. Do you want to add?
Just to interject there, on the deposits, I know one of the things that we've been advising clients is that, this is for new contracts. I'm not talking about if you're using the payment of an advance deposit as leverage to get out of, say, a 2021 meeting. But we're talking about for new contracts. Like you said, we're in the past, some of the association meeting contracts had deposits required. Many did not. That's definitely changing. That's one of the trends that we've seen. And like you said, if they had your money, they were generally taking a much harder line on cancellation because they can just keep the money and apply it to cancellation penalties and then give you a bill for the rest. We had much more success and have continued to have much more success in situations where there is no advance deposit. But if you are going to have to pay advance deposits, you want to spread it out. They may ask you to pay it all up front, but say, no, we're going to spread it out and give you, 25% of it now, maybe 25%, X number of months or years, however long out the meeting is, and so forth on a staggered basis, so that you don't have to pay that all at once. Nisha, what are some of the other provisions that we're seeing? What are some of the things that we're seeing from the hotels that are different in terms of what they're proposing, including some of the interesting kind of force majeure language that we're seeing that's very different from what we saw in the past?
Yeah, that's tending to be more common, where COVID specifically is being called out in the force majeure language, so that termination for force majeure, if it's related to COVID, is much more difficult than if it were just a standard force majeure termination. That language is now saying something to the effect of, if there is a travel ban, travel warning, or travel restriction issued by a health authority, so the CDC or a local public health authority where the hotel is located, then the group and the hotel agree to work in good faith to accommodate those issues. So it doesn't grant an automatic right to terminate without liability. Rather, what it's doing is saying the hotel and the group need to talk to each other and either reduce a room block, reduce rental space, but still try their very best to move forward with the event. And only if both parties agree, the hotel and the association or the group, if they agree, then the event can be terminated or the contract can be terminated without any sort of penalty. So it's taking force majeure out from being a one-sided termination and making it a mutual agreement for COVID specifically.
And what are some of the things that we've kind of pushed back on? What's some of the suggested changes that we've proposed making to that hotel proposed force majeure clause?
Yeah, unfortunately, the hotels aren't really allowing groups to just strike that language altogether. But what we have been able to do is change the language a little bit so that it's not so constricted for the group to be able to at least negotiate a reduced room block or potentially terminate. So instead of the only reasons for termination or modification being travel restrictions or warnings issued by a public health authority, we're trying to add in potentially corporate travel restrictions, which the group has no control over either. So if your members or your attendees are subject to those corporate travel restrictions, that should be a consideration for COVID, as well as continued space restrictions or other acts that might make it a little more impossible for you to move forward with the event as originally contracted. And we're also trying to get out some of that mutual agreement language to give the group still the right to terminate and not have to rebook. A lot of you have events that are scheduled years in advance because of the size of the event, and you can't really commit to a future rebook until 7 to 10 years down the road. So having that 2 to 3 week time frame of good faith discussions is not a very good use of anybody's time. So trying to redraft that language so that those discussions don't necessarily need to take place and the group can just go ahead and terminate for those COVID reasons.
Yeah, we're also sometimes see along those same lines, it will it'll say things like, we'll waive the cancellation penalties if you rebook a similar sized meeting within 12 or 24 months from the date of the original contracted for meeting. And like you said, that doesn't always work. You could say it's the association's annual meeting and you've already committed for the next 3 years out. You're not able to book within 12 or 24 months. What are some other, Nisha, contract kind of negotiating tips, other traps, pitfalls, things that we're seeing that we're advising our associations on in terms of their future meeting contracts?
So not necessarily traps or pitfalls, but other things we want to make sure our clients have in their contracts. Jeff, sort of ties back to what you were just saying about a rebook. In the event you have to cancel, we want to make sure you have at least the option to attempt to rebook and apply those cancellation fees to a future event. Sorry?
Sorry, I wasn't hearing you for a minute.
Oh, okay. So yeah, in the cancellation clause, we'll have specifically language that says, in the event, group must cancel the event, the cancellation penalties will be 100% of the cancellation penalties are going to be applied to a future rebooked event within whatever time frame we can get to agree to. So if your conferences are booked 2 to 3 years out, let's write into that language 36 months for the rebook. Now the hotels will likely push back for applying 100% of the cancellation penalties to a rebooked event 3 years from now, but it's a good place to start the negotiation. Similarly, we want to do that in the attrition clauses and in the cancellation penalties side, where if you have to cancel or you fall below what you anticipated you would do for rooms and food and beverage, that the hotel is obligated to attempt to resell the rooms and make up the revenue that you had to cancel or reduce your room block on. That makes it so that even if you have to cancel or reduce your room block, the hotel can't double collect, right? They're going to get a windfall if you pay cancellation or attrition fees, plus they're managing to resell those rooms anyway. So we've been writing in language that requires the hotel to provide an audit of their sales within 30 days of the end of the event, and that whatever they manage to resell would get credited back to the group. So again, that's one we have been putting into almost everything. And then ones you might not think about, have a change of brand, change of name, and bankruptcy clause in the contract. COVID hit all industries pretty hard, particularly the hospitality industry. So we've seen a lot of change in ownership and change of brand of hotels, and unfortunately a lot of hotels going bankrupt. These provisions essentially say, if, let's use Marriott, if this property stopped being owned, operated, or managed by Marriott, then the group has the right to terminate the contract without any sort of penalty. And that puts the onus on the hotel to notify the group in the event of such a change. It also says that if the hotel were to go into bankruptcy or file any foreclosure proceedings, then the group still has the opportunity to terminate without liability. Those are just effects of COVID I think nobody really saw coming, but they're helpful contract provisions for groups as they're scheduling their events.
Great, thank you. All right, we have quite a few questions that are coming in. Let me kind of try to deal with them in some order relating to what we've already talked about. So a few questions about force majeure. someone asked if the contract was signed 3 years ago, pre-COVID, then COVID was certainly not a foreseeable event at that time. And that is very much true. So force majeure clauses have two parts. One, the first part, most of them at least, the first part will say, if an act of God or a fire or other kind of unforeseen event occurs, then so that's the first part. Is there a triggering event? And most force catch-all phrase, or other unforeseen event, or including but not limited to, that sort of language. That's the first part. And for a contract that was signed pre-COVID, that's certainly going to qualify in most cases. But then the latter part says that triggering event makes it illegal or impossible for either party to perform under the contract. So I'd say 85% of force majeure clauses that were drafted pre-COVID say illegal or impossible. And the lawyers for the hotels and convention centers take the position that unless there is a state or local ban on the meeting from occurring, as we saw last year in most parts of the country, unless that's in place, then it's not illegal or impossible for you to hold the meeting. And now, like I said earlier, those restrictions are largely gone in the U.S. and there's certainly no federal ban, and never has been in that regard. So that if your force majeure clause says illegal or impossible, it's going to be very, very difficult for you to successfully utilize the force majeure clause. However, some force majeure clauses, and this is what we've always tried to negotiate, even pre-COVID, to say illegal, impossible, or commercially impracticable. And that's a term that has a certain legal meaning. And if it says commercially impracticable, we have used that as leverage to say, look, if we can't get a majority of our attendees to show up, or a majority of our exhibitors or sponsors or whatnot, then it is commercially impracticable for us to hold the meeting. Now, if that's the case, you do have some leverage to potentially utilize your force majeure clause to try to get you out of that contract. Now, someone asks, if there's a public health advisory in place, warning about the dangers of COVID and whatnot, is that going to be enough to make it illegal or impossible? And the position of the hotel and convention center lawyers is generally no. It's got to be a ban on gatherings like we saw last year. That being said, when we draft termination notices based on force majeure, we always include those sorts of things, CDC warnings, local, state and local health advisories and things like that. So it can be, useful leverage, but in and of itself, it's generally not going to help you to get out of the contract. All right, let's talk about in-person meetings for a minute, because as you know, and there's a number of questions here from associations that are planning to conduct in-person meetings this year. How do you do it in a way that mitigates the association's potential liability, particularly from attendees alleging that they attended your event and they contracted COVID there, and that you were negligent in how you conducted the meeting and therefore you should be held liable? What are the sorts of things you can do? And then related to that, there's a number of questions about vaccination mandates and requiring proof of vaccination, along with liability waivers. So let me talk for a minute about all of those things. First off, in order to avoid liability for how you conduct the meeting and protecting the health and safety of your attendees and your staff, what you need to basically show is that you are not, and you were not, negligent in how you conducted the meeting. So how do you show that? Well, first off, you need to be sure that you are following any state and local mandates. So for instance, a number of states and cities, including DC, where we're located, do have indoor mask mandates. And so if you're in a location that has an indoor mask mandate, obviously you have to follow it. Beyond anything that's mandated, and there's not a lot of things that are mandated in connection with how you conduct meetings, then you look to what other guidance is out there for how you safely conduct meetings. What you're trying to show is you were not negligent, that you met the prevailing standard of care that exists at the time. And so where do you find that standard of care? Well, you don't find it in one place. You look in lots of different places, and you start with the CDC, because the CDC has guidance out there, which they just updated, I think, in July, for how to safely conduct large gatherings. And you want to follow that guidance as much as you possibly can, and you want to require the hotel or convention center to follow it as much as they can, because a lot of the things are on the venue itself, things like sanitation and ventilation and food service and other things like that. And so you want to get the hotel or the convention center or the meeting venue to agree to follow that guidance as much as possible, and whatever other guidance exists at the state and local level, and other best practices. The more of those things you do, the less likely it's going to be held that you are being negligent. Now, related to that, and obviously this is a very polarizing issue, as we all know, is the issue of vaccination mandates. Many associations that are proceeding with in-person meetings are either A, mandating full COVID vaccinations for all attendees and staff, or they're mandating vaccinations or proof of a negative COVID test within usually 48 or 72 hours before the start of the meeting. So some are saying either or, some are saying it's vaccination or you cannot attend. Those mandates are lawful, and requiring proof of vaccination, if you choose to do that, is lawful. I will say that there are 5 states, Florida, Texas are the 2 biggest ones, North Dakota, Iowa, and Alabama. Those 5 states, at least at the last that we checked, ban businesses in the state from requiring proof of vaccination as a precondition to entering the business, like a restaurant or a store or a hotel. But even in Texas and Florida, which are the 2 biggest states there and where many associations hold meetings, what the hotel lawyers so far, at least anecdotally, seem to be saying is that even though the hotel is not legally able to require proof of vaccination to come into the hotel, you as a meeting sponsor that's just leasing space in the hotel, they're okay with you imposing a vaccination mandate. They just can't do it themselves. Now that could change, but right now that's the position that they seem to be taking. So that's one thing to keep in mind. Another thing to keep in mind with respect to vaccination mandates is that the Title III of the Americans with Disabilities Act, which requires in places of public accommodation, which would certainly include hotels and convention centers, you have to make a reasonable accommodation for those with a qualifying disability to enable them to participate. And it seems, again, there's really very little litigation history on this so far, but it would seem that if someone has a health issue, a medical issue that prevents them from getting vaccinated, then it would seem that you need to make a reasonable accommodation for that individual to enable them to participate. And that reasonable accommodation could be, 72 or 48 hour proof of a negative PCR COVID test, and or it could be, making the content from the meeting available. If you have a hybrid option, a virtual option, and a hybrid meeting, that would certainly seem to be a reasonable accommodation in most cases. But keep in mind, you do have to make that reasonable accommodation for those with a qualifying medical condition. We have seen a lot of associations also making exceptions from their vaccination mandate for conferences for those with a religious objection, a sincerely held religious belief that prevents them from being vaccinated. You don't legally have to do that. It's certainly permissible if you want to do that, but you legally don't have to. That is required in the employment setting. So if you're going to have a vaccination mandate in your workforce, you have to make reasonable accommodations both under the ADA, the employment provisions of the Americans with Disabilities Act, and due to Title VII of the Civil Rights Act, you have to make a reasonable accommodation for someone with a sincerely held religious belief that prevents them from getting vaccinated. But those vaccination exceptions, the exception for the religious belief does not apply in the conference setting because Title VII of the Civil Rights Act does not extend to conference attendees. Finally, on the issue of liability waivers, we get this question all of the time. We get asked all the time, if we're going to have our attendee, if we're going to hold an in-person conference, should we have our attendees sign or agree to, electronically click and accept that they agree to a liability waiver saying, I recognize that this is COVID is a very dangerous virus, and that no matter what the association does, it can't guarantee that I won't contract the virus. And if I do contract the virus at your meeting, I agree not to hold the association liable. Should you do that? To me, it's a no-brainer. Unless you're getting some real strong political pushback from your membership or your attendees, which we generally have not seen, To me, it's a no-brainer. Liability waivers are not always bulletproof. They can be shot down for a variety of reasons in court. But generally speaking, if it's drafted properly and there's a clear and affirmative click and accept by the attendee, in most cases, unless the association is grossly negligent, it is going to go a long way to helping protect the association. It doesn't mean that you shouldn't do all the other things I talked about earlier, but it is, I think, a kind of a helpful no-brainer tool. And the other thing that we encourage our clients to add into their liability waivers is something that says, I, the attendee, agreed to follow all of the, rules and terms and conditions that the association imposes, whether it's mask mandates or anything else. Sorry, I'm just scrolling through some of these questions. There's a question here about insurance and two things, both liability insurance and event cancellation insurance. A couple things to note. Since January of 2020, all of the event cancellation insurance carriers made it impossible for you to purchase coverage for what are called communicable disease claims. So any claims arising from a communicable disease, including COVID, used to be able to pay an extra premium in order to get communicable disease coverage in your event cancellation insurance policies. But for all policies that have been written and issued since mid-January of last year, that's no longer possible and is likely not going to be possible for the foreseeable future. It doesn't mean that event cancellation insurance is not still valuable. There are many other covered claims, what are called perils, that can be covered. And if your conference is a major revenue source for your association, it's something definitely worth looking into. But unfortunately, all insurance premiums have gone up significantly over the last year, on average about 30% for virtually all types of insurance. So it has gotten more expensive. You need to do a cost-benefit analysis, but it's something definitely worth looking into. The other type of insurance that we talk about in the COVID era is commercial general liability insurance, what a lot of folks call slip and fall insurance, which generally covers claims that arise from your conferences, from accidents and things like that, including bodily injury and property damage. And arguably, at least, and I say arguably because a lot of this stuff is in the middle of being litigated, COVID-related claims for policies that were issued pre-pandemic, if someone alleged that they contracted the virus at your event and they sue your association, your commercial general liability insurance in the past arguably should provide coverage for that. But just like in event cancellation insurance, we are now seeing the leading commercial general liability insurance carriers exclude coverage for COVID-related claims from new policies that are being issued. So again, if a policy was issued pre-pandemic or whenever, and it did not contain such an exclusion, then the insurance carrier is bound to honor that. But for new policies, unfortunately, that does not seem to be the case anymore. All right, there is no shortage of questions, that's for sure. Yeah, Nisha, if you can help me kind of scroll through these. Try to cover things that we haven't covered already. How do you know or are able to verify hotel bookings in terms of the resell clause? Do you want to talk about, kind of the audit and inspection rights that we always try to put into these?
So for the resell, right, to make sure that the hotel has resold rooms or that you can verify whether or not they've resold, there is specific language in these contracts that say the hotel will provide an audit report, and that's sort of standard leading up to an event as well, because you want to see what your room pickup is. So they would essentially expand their audit report to include the entirety of the hotel, not just your room block, and that's how they would be able to verify that rooms that were within your room block sold, even though it wasn't, related to your event, and they would credit you back. It's usually a proportion of it. It's not a portion of it. It's not the entirety. You're not going to get 100% credit because they take some off for administrative costs, but usually they would credit back the group. Average, I would think it's about 80% from what we've seen, but you need to make sure that you have the right to receive that audit report as part of the contract terms.
Another issue that we haven't really talked about much, but that's critical, is attrition. And I referenced this at the top of the hour. If you are going to proceed with an in-person meeting, and hotels, convention centers, and meeting venues, they want you to proceed with in-person meetings, especially this year. I mean, and generally, obviously, in future years too. But if you are going to proceed with an in-person meeting, you can almost be guaranteed that you're going to have significantly reduced attendance from what you would have had pre-pandemic and when you initially contracted for the meeting. So as I said earlier, if you don't address the attrition penalties, you can be hit with some really, really significant penalties. So it's absolutely critical, and the sooner the better, that if you're planning on moving ahead, work with the hotel to get them to either eliminate attrition penalties altogether, and we've been able to do that in some cases for some of our clients. Obviously, every negotiation is different, depending on what kind of leverage you have and what kind of position the hotel or convention center is in, and all of that. What state you're located in, all of these things matter. But you really have to either eliminate or significantly reduce your guaranteed minimums for sleeping room revenue and food and beverage revenue and the corresponding attrition penalties, or you're going to get hit with some really, really significant bills at the end. It's absolutely critical, but we have seen great success by some of the associations in terms of being able to do that successfully. Some contracts don't have, if you're a larger association and you have kind of these big citywide meetings, often those associations, which are some of our clients, have the leverage to negotiate out attrition penalties altogether at the front end. But that is, but that's not the case for most associations.
And I think also, Jeff, with that, talking about future contracts, when you're going to sign, another provision we want to see included in those contracts is a room block review. So if you're scheduling an event that's 2 or 3 years out, or even within the next 12 months, give yourself the opportunity to change that room block or modify the room block, increase or decrease by an aggregate of, let's say, 15 or 20%, because you just don't know, right? Leading up to an event that's a while away, you have no real way to know whether or not you're going to meet the numbers you originally contracted for. So you can say that, 3 months, 6 weeks, 12 weeks, whatever makes sense for your organization ahead of the event, the group has the right to reduce or increase the room block in the corresponding food and beverage minimum and event space by up to 10, 15, 20%, whatever we can get the hotel to agree to. So that way you've given yourself some flexibility as you're planning the event and as things may continue to evolve.
Yeah. All right, we got a number of questions back to vaccination mandates. We try to address them quickly. Someone asked, isn't requiring vaccine mandates a violation of the Constitution? It's not, because this is not a government action. An association is a private actor, and the constitutional rights in this case would only come into play if it's a government agency, and obviously that's an issue that's being litigated right now, as we all know. But as a private organization, you are completely free to impose whatever sort of vaccination mandates you want. I'm not sitting here advising that you do or don't do it. I'm just saying it is lawful for you to do it. You just have to make that one exception to make a reasonable accommodation for those with a qualifying medical condition that prevents them from being vaccinated. And many associations are, like I said earlier, going the route of vaccination mandate or 48 or 72 hour proof of a negative PCR COVID test. Someone else asked, doesn't requiring proof of vaccination violate HIPAA laws? The answer is no, it does not, because most associations are not going to be healthcare providers or business associates of healthcare providers that are covered by HIPAA. And even the EEOC has said in the employment context that it's not a violation of HIPAA to ask for proof of vaccination. There is a provision in the Americans with Disabilities Act that requires employers, if you have confidential medical information about your employees, there's a strict confidentiality obligation, and you're not supposed to keep that that information in the person's personnel file. So if on the back to the workplace front, if you're going to have a vaccination mandate in the workplace and you're going to require proof of vaccination, you need to be very careful to keep that information on a very limited need-to-know basis, keep it in a very confidential spreadsheet or whatnot, make sure you only have 1 or 2 people within the association that are gathering that information, and keep it strictly confidential. Let's see what else here. Oh, and on the vaccine and the proof of vaccination, if you are going to do that, you can we're starting to see this in restaurants and venues, and certainly in some states like in New York, where proof of vaccination is being required. You can do it in multiple ways. You can have someone literally checking vaccination cards and IDs, but as we've all probably seen and read, vaccination cards are very easy fraud is very easy and unfortunately increasingly rampant in that area. So what a lot of associations are doing, A, just to speed up and make the process more efficient, B, to kind of mitigate liability risk for the association, and C, to ensure and help to mitigate fraud in this area, is what many associations are doing is contracting with one of several companies out there. Probably the one we're seeing the most in the association conference context is Clear, the company that does the airport security screenings. Clear has a service and an app that they utilize where you can essentially pre-clear your conference attendees. So you upload a copy of your vaccination card and your ID, and certain other information about your doses of the vaccine to their site, and then they go through a process and they check certain databases, and then they clear you, and then it's an app on your phone with a little QR code that can just be scanned when your attendees arrive. And for those who don't participate, they can do it the old-fashioned way and show a copy of their vaccination card. But generally, I would recommend that if you are going to require proof of vaccination, I would contract with one of those companies in order to do that. Are you allowed to ask for confirmation of religious exemption or an ADA exemption? So as I said, that religious exemption for vaccination mandates is only going to apply in the employment setting, not in the conference setting. Although we have seen some associations in their vaccination policies for their conferences are allowing, you're certainly permitted to do that, it's just not legally required. In terms of the ADA exemption, ADA has been around for a long time. There is clear precedent that says that if someone is going to claim an ADA exception from a vaccination mandate, now again, if you have an alternative of a negative COVID test, then that's the reasonable accommodation. You really don't have to worry about this. But if you don't have the alternative of a negative COVID test, you are allowed to ask for proof of a qualifying medical condition. You can ask for a doctor's note, so to speak, in order to establish that. There are certain lines in terms of how far you can go and what sort of questions you can ask, but you certainly can ask. You are legally allowed to ask for substantiation of that. Someone asked, isn't it problematic to request proof of vaccination when fake vaccine records are so readily available? And that's why I suggested utilizing Clear or another company like that. Someone asked, how much does Clear cost? I have no idea, unfortunately. And there are other companies out there that are doing this. And I just saw, it's the ASA Summit Awards dinner in a week or two in DC. And I saw that they are imposing a proof of vaccination requirement in order to attend the event. And they offered up 2 different apps, Clear and another one that you can sign up in advance and use that, or just come and show show a copy of your vaccination card. Someone responded that Clear costs $4 per attendee. Okay. Another issue that we've seen for associations that are mandating vaccinations as a precondition of conference attendance, we've seen some of those associations go to the hotels and say, look, this is what we're going to do. We want to ask that you ensure that all of your staff that are going to be around our attendees are fully vaccinated, or sometimes have proof of a negative COVID test, as well as vendors that the hotels are bringing in. And we've seen most hotels be very cooperative in that regard. That doesn't mean it's going to be the case in every situation, but it's something to keep in mind. Because if you want to mandate vaccines for your attendees, you're going to want to make sure anyone at the hotel, at the convention center, that your attendees are around are subject to the same requirements. And we're seeing a lot of that back to the employment context. We're seeing a lot of associations that are mandating vaccines for staff are also mandating proof of vaccination for visitors and vendors and others that are coming into the workplace.
There's one, Jeff, here. How do we protect ourselves from hosting at a hotel that significantly reduced services and amenities since we signed the contract? So things that your restaurants are closed, the spa is no longer available, the pool is no longer available, all of the things that the guests are coming to utilize at the hotel. What happens if they're not open? And we dealt with that a good bit last year too. Even when hotels were trying to argue, they were still able to host the events because they were open and functioning. We were able to argue back that while part of the amenities and all of these concessions you were offering us, 25% off spa services, 10% discount at the restaurants, things like that, you are no longer, as the hotel, able to fulfill your obligations of the contract, and therefore we should be able to terminate since you can't give us what we signed for. That has been possible. It's not based on any particular provision of the contract, but rather just the hotel's ability to be able to perform as contracted.
Yeah, and we are still seeing that now, and when we even dealt with it very recently for a client. So it's not an issue of force majeure, but it's an issue of potentially what's called anticipatory breach of contract, that you contracted with the hotel, or usually we're talking about hotels, to provide a certain level of service, and if they don't have the proper staffing or a lot of the amenities are closed, those are essential aspects of what you were contracting for, and if those things are not going to be open, then we've utilized that as leverage to say, look, you can't fulfill the contract as contracted for, therefore you're in anticipatory breach of contract, therefore we can get out without penalty. Yeah, so we have a question, and this gets tougher, about, say, trying to cancel events for next year. We dealt with the same issue last year where a lot of associations were already wanting to cancel 2021 events when it seemed like things were going to turn the corner after vaccines came online. That's increasingly difficult to do. The further out, just because no one knows what the situation is going to be, it's impossible to use force majeure as leverage in this case to cancel an April 2022 meeting. But you may be able to negotiate and offer up other leverage, offer up another meeting in the future or whatever else. Just like in any negotiation, you have to sweeten the pot. Another tool that we've utilized to try to incentivize a hotel to do a rebook, we talked about advanced deposits, but another thing is increasing the food and beverage minimum spend. Have a bit of a nicer event for your attendees, things like that. It's another tool in the toolbox that you can utilize to try to incentivize a hotel to do a rebook. Question about, do we have any data on the percentage of associations who are requiring mandatory vaccination or a negative COVID test as a condition of attendance versus those who are not? And I really don't have any data. I'd say anecdotally from the 400 plus associations that we work with, I'd say most that at least have come to us to ask for our advice and counsel on these things that are going ahead with in-person meetings are imposing some sort of a mandatory vaccination requirement and or proof of a negative COVID test. And I'd say that's probably the trend I'm seeing the most, is those two alternatives. But we have some, that are mandating vaccinations, period. But as we all know, it's a highly politically charged issue. And these are really difficult decisions that so many associations are struggling with. Well, it looks like we are at the top of the hour. I apologize to those of you whose questions we did not get to, although I think we got to most of them for the most part. So hopefully you found this helpful. Nisha, thank you very much for your participation too. And Mark, I'll turn it back over to you. Thanks for the opportunity to speak to everyone today.
Jeff and Nisha, thank you both very, very much. Hey, as a reminder, today's webinar has been recorded. Following the program, you will receive a brief evaluation that we encourage you to complete, and we will make a link to the recorded webinar available as well. And by the way, you can view all of our previously recorded webinars from this series for free by visiting associationalliance.org and going to the COVID-19 Resource Center. So thank you all again for attending today. Thank you, Jeff and Nisha. And to all of you, enjoy the rest of your day. Take care.